Next, I move on to the change in the law arising from Jeanette Ang's case. I have a query on the change in Clause 11. Clause 11 will amend the law set out in the 2011 High Court case of Ang, Jeanette and Public Prosecutor to make it easier for the prosecution to prove certain money laundering offences. Let me summarize why. In Jeanette Ang's case, the High Court had ruled that to prove that an accused had committed money laundering, the prosecution needed to show that the monies in the accused's accounts came from criminal conduct. Clause 11 would remove this requirement. Instead, it would simply be sufficient for the prosecution to show that the accused had a guilty frame of mind, that is, that he knew or had reason to believe that the monies came from criminal conduct. In explaining the rationale for the change, the ministry pointed to evidentiary difficulties. It was said that the proceeds of crime could have been channeled through other bank accounts in other jurisdictions before coming to the accused. It was stated to be difficult to obtain documents from foreign banks to prove the trail of monies. And I think earlier, the Minister also touched on this point. So this amendment in Clause 11 would fall squarely within a concern raised by the judge in the Jeanette Ang case. The court in that case had stressed the importance of requiring the prosecution to prove the trail of monies. The judge noted that if the prosecution did not need to prove that the monies came from criminal conduct, then a person could be prosecuted for money laundering in situations where he mistakenly thought that the monies were the proceeds of crime, when the monies were in fact clean monies. The court opined that prosecuting such a mistaken person would not further the purposes of the anti-money laundering conventions and laws. With the change in Clause 11, how will this risk be addressed?
Next, I will touch on the amendments to Section 56 of the CDSA. Mr. Chu, Mr. Goh, Mr. Leong, Ms. Lim, Mr. Ng, Associate Professor Raswana, Mr. Saktiandi, Mr. Sharil Taha, Mr. Wee, and Mr. Zulkarnain asked about the elements of proof, impact on victim restitution and international cooperation. This amendment will allow us to better act against money laundering cases and to pursue persons who exploit our financial system, whether the subject is a money mule or kingpin. This would in turn facilitate confiscation of illicit monies and any subsequent restitution to victims. To clarify, the prosecution would still have to prove the physical element of the offence, namely that there was transferring, converting, receiving or acquiring of the property by the accused. What is no longer required? Only the need to prove, as a physical element of the offence, that the property is in fact the benefits of criminal conduct. The prosecution would also have to prove the necessary fault element, that the person dealing with the monies knew or had reasonable grounds to believe that he was dealing with the benefits of criminal conduct. Other jurisdictions, such as Hong Kong and Australia, already have similar laws, where there is no need to prove a direct link between the property and criminal conduct. A few members have questions on reasonableness, both what the prosecution must do to show reasonable grounds and defendants can do to demonstrate reasonable doubt. Members will appreciate that we are unable to provide examples of how a defendant might show reasonable doubt to counter the prosecution's assertion of reasonable grounds. Explicitly spelling this out may also unwittingly benefit criminals. Such a determination would be made by the courts based on the specifics of the case. These are not matters unfamiliar to the courts. Proof of reasonableness is something that they deal with all the time. An innocent person engaged in legitimate business should easily be able to show that the monies received were not benefits from criminal conduct and that he did not have the necessary fault element. Legitimate businesses that do not break the laws in Singapore, therefore, need not worry about this amendment.